let me just tell Alicia. Don't worry, I have worked it out. It is being recorded. Okay, so that's good. Before we start, just on property management, does anybody have any just general questions about what we're doing, what we need to do, about anything really, just life in general? Well, obviously APC related. But if you have any questions, please feel free just to unmute and ask away, and I'll be happy to answer them. Okay, that's good. Well, if there are no questions, let's crack on with property management revision webcast. Okay, so the purpose of the webcast this evening is to give you an overview of the property management competency. Now, this is, of course, relevant to those, unsurprisingly, that are doing property management, but is also relevant for those doing the sort of the commercial pathway, because there are lots of things here, such as service charges and assignments and sublettings and rent deposits that are applicable to everybody. So, you know, it is quite useful just to understand. And of course, property management as a competency is a very wide subject. There's lots to potentially learn. And for the property managers amongst you, some of this might seem quite basic, quite simplistic, and obviously apologies for that. But what I'm trying to do is to pick out the most relevant information, if you like, from this competency, and try and sort of give you some guidance on what we as the assessors commonly would ask questions on. Okay, so the first thing I want to talk about is the competency itself. So this competency covers all aspects of day-to-day functions associated with property management. It includes issues relating to works, health and safety, landlord and tenant relationships, and service charges. In general, any matter associated with the smooth running of a property. So we've got obviously levels 1, level 2, and level 3. Let me just concentrate on levels 2 and 3 at the moment, because if you're doing property management, you'll either be doing it to 2 or 3. So level 2, apply the principles of property management to provide solutions to issues affecting both owners and occupiers of real estate. Managing property from both a landlord and tenant perspective, and understand the key factors from each viewpoint. Understanding legal requirements associated with multi-let property and or managed property. Understanding property management accounting principles from the landlord and tenant perspective, and also the requirements of law and RICS. And understanding courses of action in relation to breaches of lease by landlord and tenant. And then finally, at level 3, provide evidence of reasoned advice, including the preparation and presentation of reports in relation to property management, participating in all aspects of property management, including works, emergency reactive maintenance, planned programs, budgets, etc. And applying your negotiation, communication, and business skills in relation to contentious issues with both landlord and tenant, and participating in issues such as applications for license to assign or for works together with the associated legal frameworks. One of the most important things, especially at the moment, is how you deal with the remedies for non-payment of rent. Okay, so I'd like to ask a question, and if you've got your, if you want to turn your microphones on, if you know the answer, or you can write it in the chat box. So here's the question. You are the property manager of a property, obviously. Doesn't really matter what it is. And there's a tenant that has not paid the quarter's rent. Okay, so just leaving aside for a second where we are at the moment in this crazy world that we live in, but just take normal sort of circumstances. So the rent demand went out March quarter day, nothing. We're now coming towards the end of April, nada. What is the strategy? What do you do? And I'm talking about from the very, very beginning, right the way through to the last resort. Let's go through it. What do you think? And if you want to answer over the line, switch your microphones on. What's the first thing that you do when you haven't received rent?
Make contact with the tenant. Okay,
good. So the first thing is making contact with the tenant. The most important thing. Okay, how would you do that?
Formal letter or email.
Okay, fine. So generally, we start off by making contact with the tenant. Normally, it's an email because it's quick and it's easy. Then it might be a formal letter. We might also, there's this strange thing called a telephone, which we used to use. And we might even pick up the phone to the tenant and ask to talk to them. I know it doesn't happen very often, but it could happen, you know. But the most important thing is, you see, in the interview, when people get asked that question, which gets asked a lot of people go straight to CRA, payment plan, even forfeiture, you know, without giving any serious consideration, any serious thought to, well, what actually happens in the interim? You know, we're not going to go straight for that. We need to go through the various stages. So if you're doing property management to level 3, that's the sort of process that you're going to need to go through in your head before you answer the question. Okay, so we make contact with the tenant. Now, if there is no response from the tenant, what would you say? If there was no, or what would you do? You've emailed, no response. You have called them, no response, and you've written to the head office or whatever, no response. What would you do? What's the next stage? Think about it logically. So you've now got some arrears, and you've now got a client that's saying, well, you know, what are we going to do about this sort of situation? What's the next step? What do you see if there is something available? What might the landlord hold, or you hold, on behalf of the landlord that would enable, yes, good, a rent deposit, excellent. Okay, so if there isn't a rent deposit, is there any other way of perhaps having some sort of security? What else might you pursue? Good, a guarantor. Okay, so when a tenant doesn't pay the rent or is persistently late in the payment of rent, the first thing that a property manager should do is to meet the tenant on site to discuss. Now, we've mentioned and we've talked about communicating with the tenant. Why do you think, and you've got to think outside the box now, why do you think it's important, if possible, to meet with the tenant on site to discuss why they haven't paid the rent? Why do you think it's important to meet with the tenant on site to discuss why they haven't paid the rent, as opposed to just communicating in writing or verbally? Face-to-face meeting is easier to ascertain. In addition, you need to know, yeah, well, that's the key. Okay, you need to know, first of all, are they in occupation? And Sam makes a good point about looking at the staff and the stock and the general state of the business. And again, that's a very, very good point. Going to see the tenant at their place of business will give you a good indication of the state of the business at that time. So you'll see whether the shelves are stocked. You'll see whether the desks are manned by workers. You'll see if it's an industrial unit or a warehouse, whether there's stock on, ready for orders to be fulfilled. And that will give you an indication as to whether or not the tenant is trying it on or whether there is a general problem. And as Ellie said, you need to know that they're in occupation. Why is it important to know if they're in occupation? If you're going to do what? Why do you need to know if they're in occupation? If you're going to do serve notice, okay, what sort of notice? In the interview, you can't just say serve notice. CRA, okay, 7-day notice, good. So if you're going to CRA them, okay, commercial rent arrears recovery, which we'll come on to, there's no point doing it if the tenant isn't in occupation. Okay, so therefore the first thing we do is we go and see the tenant on site. If we're unable to do that, then we will look to make communication with them either via telephone or email. Now, we talk about covenant strength of tenants. Now, here you have a situation where a tenant hasn't paid their rent. Okay, it happens. But before making a decision on potential remedies for non-payment of rent, the property manager should ask to see some accounts. Why? Because that will give an indication again as to whether or not the tenant is trying it on, or whether there is a general or a genuine, issue about paying this quarter's rent. So you'll be able to see whether or not there are whether turnover is down, whether costs have gone up, and why. Okay, so always ask before you make a decision, before you make a recommendation to the client about remedies for non-payment of rent, ask to see the tenant's accounts. So now we move into the options that are available to you. So you've now tried communication, and let's just say, for example, the tenant's in occupation, they provided their accounts, and quite clearly, as a result of COVID-19 or whatever, they're struggling. Okay, turnover is down, business is bad, but you want to keep them in occupation. Okay, so you may look at a payment plan. You could also look at pursuing a guarantor, authorized guarantee agreement for a former tenant, and you can draw down on the rent deposit if worst comes to the worst. Then we have CRA as the next step. Then we have a stat demand. Then we have surrender, and ultimately we have forfeiture. So may I suggest, ladies and gentlemen, that are doing property management, particularly to level 3, have those 7 things really, surrender and forfeiture is kind of 2. Have those things in your head when you're asked about the remedies for non-payment of rent, so that you can methodically go through what the easiest option is, which is drawing down on the rent deposit, then pursuing a guarantor if there is, then a payment plan, then CRA, and so on and so forth, okay? Right up until the worst case scenario, which is forfeiture. Bear with me one sec, because Right. Okay. Let's now turn to the various options in more detail. Payment plan. So read the accounts first to see if it's justified. Generally, it's a short-term measure. It's agreed in writing. It's personal to the tenant, and therefore it's quite an easy, swift, reasonably mutually beneficial status, if you like. So that's why we do a lot of payment plans. And for those of you that are doing property management now, I'm sure that there will be lots of payment plans that that take place over the next quarter. Guarantor. Okay, so you've got an authorised guarantee agreement. I'm going to come on to this particular section in a bit more detail later. But first of all, check, is there a guarantor in place? Check the lease. Section 17 of the Landlord and Tenant Covenants Act of 1995 allows the landlord to claim against the guarantor within 6 months. Okay, so Section 17 of the Landlord and Tenant Covenants Act allows the landlord to claim against the guarantor within 6 months. If the guarantor settles the arrears, then they're entitled to take an overriding lease. Okay, so you've got to think about whether or not you actually want to pursue the guarantor. Is the guarantor a better covenant? Generally speaking, it's a parent company, so it will be a better covenant. But think about that. Think about this guarantor having the opportunity to take an overriding lease. And of course, you know, before 1995, we had what was known as privity of contract. It's unlikely that you'd be asked questions about privity of contract in the interview because it's quite a sort of specific thing. And of course, it hasn't existed for the best part of 25 years. Is it 25 years? Blimey, yeah. 25 years. God, that makes me feel old. So it's unusual to get a lease that is sort of a privity of contract lease. But of course, you know, back in the 80s and 90s and even 1970s, it wasn't unusual for tenants to take very long occupational leases of 99 years. So that's why there might be privity of contract. If there is an authorised guarantee agreement, look in terms of the lease itself. What are the terms of the authorised guarantee agreement? Remember, of course, that it only applies to one assignment and not to sublettings. So in other words, if you've got a property let to Tesco and they want to assign, and you look at the lease and they are permitted to assign, subject to landlord's consent not to be unreasonably withheld or delayed. And they want to assign their lease to, I don't know, a local convenience store. So Tesco remain on the hook through their authorised guarantee agreement. But if the local convenience store wants to assign that lease to another local convenience store, Tesco are off the hook. And then all of a sudden, that investment that you bought for 5% is now let to a local convenience store with another local convenience store as the guarantor, and it's not going to be worth as much. So therefore, if you had a property let to a 5A1 covenant, you would ensure that the authorised guarantee agreement was carefully worded so that they were only permitted to assign the lease to a tenant of similar covenant strength. Drawing down on the rent deposit. If available, landlord can draw down on the rent deposit. The rent deposit will need to be attached to the lease, which will require topping up. And that's why the drawing down of a rent deposit is actually not particularly common, because ultimately, you draw down on the rent deposit and then the tenant has to top it up in 7 days. Well, if they could afford to top it up, they could afford to pay the rent. So, you know, really, all it's going to do is just to buy a little bit more time. Generally speaking, landlords will draw down the rent deposit when they are forfeiting the lease, so that they know they're not going to get any other money back. So therefore, at least by drawing down the rent deposit, they get something back. CRA. Excuse me 1 second. Yeah, Ellie's just made a point. I'd note that before drawing down on deposit, the rent deposit is reviewed, as that will often stipulate certain conditions. Yeah, that is correct. With any kind of deed or anything related to the lease, yeah, you should always make sure that you make it very clear that you are reviewing the lease to make sure that there are no sort of particular conditions. That's absolutely correct. Somebody's just messaged me saying, "Hi, Mark, but you've come up as an unknown user, so I don't know who you are." Robert asked if you can allow him into the meeting. Oh, hi, right. Just bear with me 1 sec. Let me come out of this then. Let's hope that this works. Ah, here we go. Robert, are you there? Robert, you may have your microphone switched off. Okay, well, hopefully Robert is on the call. So, right, let's just go back to where we were. Okay. Right, commercial rent arrears recovery. We're going to go into that just in 1 second. Okay. Commercial rent arrears recovery. For those of you that are doing property management, and in fact, actually, it's quite appropriate for landlord and tenants as well, leasing and letting, and purchase and sales. So, but especially for property managers, you must know about CRA. So CRA replaced what was known as distress, where the bailiff would be sent into a property to remove goods to the value of the debt. Now that's been replaced by CRA, and that's the Commercial Rent Arrears Recovery Scheme. Main changes. So the debt that can be recovered can only be available in pure rent arrears cases. Okay, so only rent or VAT on that rent and interest on that rent will be recovered. In other words, insurance shortfall, service charge shortfall cannot be recovered through CRA. Service charge can, of course, be recovered through SCRA, service charge arrears recovery. But for this particular purpose, it's just the commercial rent arrears recovery. Okay, so if you have a property which is a mixed use property, i.e. a shop on the ground floor and a flat upstairs, then the CRA will only apply to the ground floor. If, however, it is a property that is ground floor and first floor with residential, but it's let on an overriding lease to the commercial tenant, then the whole thing can be CRA'd. Okay, but if it's separate, so there's a lease of the ground floor and then a separate AST on the first floor, that first floor can't be CRA'd because that's residential. CRA refers only to commercial. Now, there are situations where rents are inclusive of service charge or rates or whatever, maybe even insurance. If that's the case, okay, the rent element has to be stripped out. In other words, you have to work out what the rent part is. Looking at the rent demands, you can work out what the service charge is, what the insurance is, what the rates are, and that leaves the rent, and then you can then attempt to recover that. Before recovery can be sought under the legislation, the debt must be a minimum sum, and this is set at 7 days rent arrears. How to recover it? So the certified bailiff is now known as an enforcement officer, and they are permitted to enter the premises after having served a warning letter to the tenants, advising them of the 7-day notice period. Okay, so the letter will say that in accordance with your lease, you're in default. We've been instructed by the landlord to recover the debt by way of seizing goods, and we will be visiting the premises in 7 days to carry out an inventory. Okay. Now, a rarely known fact is that, of course, you can only enter the premises if they're occupied by the tenant. You can't break in, you can't force your way in, you have to be permitted to enter by the defaulting tenant. So what do you think might happen if, on serving the 7-day warning letter and on receipt of the 7-day warning letter, the tenant thinks, well, if I'm not in occupation, they can't enter the premises. So I'll clear out my property, put it into the back of a lorry, and disappear for a week or two and then come back. Do you think there is a way of speeding up that process? In other words, speeding up that 7 days notice period? What do you think you might have to do in order to speed up the process, if you believe or if you have evidence that the tenant is likely to not be in occupation? Court order is correct. Yes. Basically, if you can demonstrate that having previously attempted to bailiff the tenants or rather tenants, they've done a runner, then yes, you are entitled to get a court order to enter the premises in a shorter period of time without giving them notice. Enforcement agents may not take control of goods which have a value which is more than the debt together with costs. So in other words, that's why they carry out an inventory, work out the value of the goods, and then obviously they can only take up to the value of the debt. So can you tell me, either using your microphones or in the chat box, what are the enforcement agents actually permitted to take? What can they take? They can take goods. Okay. When you say goods, let me give you an example. Movable goods. Okay. So, Ellie, do you mean stock? Yeah. Okay. Fine. So let's say, for example, that it's a barber's. Okay. So if you go into a barber's, you've got, and I'll describe it for you. You've got sinks, you've got chairs, you've got a cash point, you've got TVs on the walls, you've got I don't know, let's say some video games. Okay, keep the customers occupied. What could you remove? Okay, yeah. What could you remove from that barber's? Okay, so not fixtures and fittings. So if, okay, so there are TVs on the walls, yeah? Would that count as fixtures and fittings? Okay, fine. So the answer is yeah. You can't take items which are necessary for the operation of the business. Otherwise, how are they ever going to repay the debt? But in the example that I've given you, the TVs belong to the tenant. They are an asset of the tenant. They are not essential to the running of the business. Therefore, they can be taken. The video games that I gave you as an example might be on a hire purchase agreement. And if they are, they cannot be taken, okay? They have to belong to the tenant, okay? So like if you were in an office and there was a photocopier, for example, or computers, which are on an HP agreement, they do not belong to the tenant, they belong to the finance company, therefore they cannot be used to pay down a debt. It has to be assets owned by the tenant. Okay, so that's just sort of summarizing what I've said. The enforcement agent is only permitted to take control of goods belonging to the debtor. Previously, in some circumstances, goods belonging to third parties could be distrained on. Obviously, that's not the case now. Goods which are necessary for the debtor's personal use or in connection with employment, business, trade, profession, study, or education are exempt up to an aggregate value of £1,350. Items in use by the debtor may not be taken control of if such action is likely to result in a breach of the peace. Landlords will not be able to use the new remedy if part of the property, as we said, has been used for residential purposes. Okay, so that is CRA. Hopefully that you're comfortable with that, and you can talk through that if you need to do so. If you have any questions about CRA, please let me know. Next up is hold on one sec. Statutory demand. So statutory demand is a more formal, aggressive tactic where solicitors serve a notice, which is effectively pursuing bankruptcy. It is advisable only when there is no dispute about the level of arrears. As I said, it can be seen as an aggressive tactic. The tenant has 21 days to pay the arrears, and it's used for debts in excess of £750,000. Now we move on to the more sort of significant tactics for non-payment of rent. So can anybody tell me what is the difference between a surrender and forfeiture? What is the difference between surrender and forfeiture? A surrender is agreed between the parties. Yeah, okay. So yeah, I think that's a forfeiture of the unilateral. Yeah, that's a pretty good answer. So the surrender is a mutual agreement between the parties, effectively, as we said there, to release the tenant from his obligations. So the tenant goes to the landlord and says, for whatever reason, I don't want to be here anymore. I want to hand back my lease. Now, of course, the landlord doesn't have to accept the surrender, and in fact, would be very brave to do so in this market. But just thinking generally, why would a landlord accept a surrender from a tenant? Okay, so assuming normal market circumstances, why would a landlord accept a surrender from a tenant? If the landlord is confident of getting a better tenant in, yes, okay, both of those are correct. Well done. If the landlord is confident of getting a better tenant, in other words, if the landlord is comfortable or confident that they can re-let the premises at a higher rent and or to a better covenant, then they might agree to a surrender. However, of course, as I said, this is pretty unlikely at the moment. There doesn't have to be consideration. It can be for nil premium. So, you know, let's just say that the landlord's quite happy to take it back. One of the things you didn't mention there is if the landlord wants to occupy themselves or if they want to redevelop, you know, that's another reason why they might willingly accept a surrender. This happens commonly with leases that are inside the Act, because as you know, if a landlord wanted to redevelop and he was going to go for ground F under Section 30 of the Landlord and Tenant, the Landlord and Tenant 54 Act, he would have to pay compensation. But by agreeing a surrender of the lease, that would then alleviate that necessity. So those are just two other reasons why they might agree a surrender. And as I said, there doesn't have to be a premium. Sometimes there will be. So if the landlord really does want it back, they might pay the tenant to get to walk away. So if, for example, you've got a shop which, you know, the tenant's paying 40,000 a year, and another tenant comes along and says, look, you know, I really want that shop, and the market rent is 70,000 a year, and there's 4 years to go to the review. The landlord is losing out on 30,000 a year for 4 years. That's £120,000. So they might come to you, the tenant, and say, look, I'll pay you, say, £60,000 to surrender your lease. Because I know, not that they would tell them this, because I know that actually over the next 4 years, I'm going to gain 120,000. Now the tenant might think, well, happy days, I've just got 60 grand for walking away. But of course, then they have the costs of relocation, fitting out, etc., etc. It might not be, you know, that exciting. So then we get to the final sort of ultimate remedy, which is forfeiture. Forfeiture can occur in two forms, so or on two bases. Forfeiture for breach of the lease, and that could be for things like breach of repairing obligation, for example, and it could be for forfeiture for non-payment of rent. The two things, of course, are very, very different, and the process of forfeiture for both of those needs to be carefully understood. So firstly, I say, check to make sure there's a forfeiture clause in the lease. Now, generally speaking, the leases that I've seen, there is always a forfeiture clause in the lease. Generally speaking, it says that if the tenant has not paid their rent within 21 days of it being demanded, that the landlord has the right to forfeit the lease. And that is basically taking a walk in possession, changing the locks, putting a notice on the door, and effectively taking over the premises. However, if the tenant, and that's specifically for non-payment of rent, if the tenant, however, is in breach of their lease or anything else, then a Section 146 notice of the Law of Property Act 1925 needs to be served. And that is very different, and that has ramifications going forward, because let's say, for example, you want to take back possession of a property. They're up to date on their rent, but they're in breach of their lease because, let's say, that they've sublet it illegally. Okay. So what you do is you look at the lease, and there's a forfeiture clause. You serve a Section 146 notice, but this is the important bit. You have to wait 6 months because the tenant has the right to apply to court for relief from forfeiture. And you can't do anything for 6 months whilst you're waiting for the 6-month notice period to expire. Okay, so there's no point in forfeiting a lease for breach of repairing obligation, for example, in order that you can then re-let it, because the tenant has 6 months to remedy the breach and take back possession. Non-payment of rent, however, as I said, is different. 21 days, change the locks, assuming there's a forfeiture clause in the lease. And that deals with part 1 of the remedies for non-payment of rent. So as I said, just as a sort of catch up, as a reminder for those that were late, firstly, we look for the easiest ways of remedying. We go and talk to the tenants, find out what the situation is. We look at their accounts. Are they genuine? Are they trying it on? No, they're genuine. There's a problem. Okay. Then we look at drawing down on the rent deposit. We look at pursuing a guarantor. Then we look at a payment plan. I should just say, of course, that the payment plan, as we said earlier, is a very common remedy. But of course, it only works if you actually want the tenant to remain in occupation. And one of the things that you have to think about when considering whether or not the payment plan is the right thing to do is, A, can they afford it? But also, it will potentially save your client money if there is no alternative tenant. So some landlords will say, I'd rather have the tenant in there paying a payment plan than have it vacant. Because if it's vacant, it's going to cost me money because there's I'm going to have to pay empty rates. There's a service charge shortfall, which I'm going to have to cover, etc., etc. Okay, so that's why sometimes the payment plan is the best and easiest option. Then we have CRA, commercial rental risk recovery. Then we have stat demand, surrender, and ultimately forfeiture. Okay, now we move on to service charge. Looking at the new RICS professional statement, service charges in commercial property, first edition. The RICS stated aims are to improve general standards and to promote best practice, uniformity, fairness and transparency in the management and administration of services, charges in commercial property, and to reduce the causes of disputes and to provide guidance on the resolution of disputes if these arise. Bear with me just one sec. So I just need to charge my iPad. Clarity, uniformity, fairness, transparency, that's what the new professional statement, service charges in commercial property, is all about. You need to make sure you know it. You need to make sure you understand how service charge works. Basic principle, owners and managers, property managers, that is, must seek to recover no more than 100% of the proper and actual cost of the provision or supply of the services. Service charge budgets must be issued annually to all tenants. A signed statement showing a true and accurate record of the actual expenditure constituting the service charge must be provided annually to all tenants. All interest earned on service charge accounts must be credited to the service charge account after appropriate deductions, such as bank charges, tax, etc., have been made. Service charge, how is service charge, how is it recommended that service charges be calculated? Based on what? Floor area. How did it used to be calculated? Well, the answer is, okay, that it was always traditionally based on the floor area, or the weighted floor area, if it was a shopping centre, for example, or rateable value. The service charge covered, okay, here's another question. How are management fees now calculated? Are they a percentage of the service charge? Are they a percentage of the rent? How are management fees now calculated? Percentage of rent is what Saul says. Okay. Anybody have any other answers as to turnover of service charge? Okay. Any other answers as to how management fees are to be charged? Now, Ellie said can be a set fee. The answer is that is the basis that the service charge code actually recommends, that it's a set fixed fee based on time spent in managing the properties. You see, what was happening was that management fees used to be a percentage of the service charge. Okay. And what are we actually doing with a service charge? Well, what we're doing is we are working out the expenditure over the next year of a building and apportioning it to the tenants based on their floor area. Okay. If the managing agent's fees are related to the service charge itself, the managing agent is under no incentive to keep it low. He's going to make it as expensive as realistically possible, okay? Because therefore his management fees are higher. And the RICS said, no, that's now no longer recommended, because if you're managing a property which has little management input, you're just collecting 4 rent checks a year, the management fee should reflect that, okay? Because don't forget, who pays the managing agent's fees? That's a good question. Who pays the managing agent's fees? The tenants. Thank you. Okay. And I'm sure, well, I certainly did, but I'm sure that you would have had questions raised by tenants as to and so you have to be able to justify how you've arrived at it. So in addition to the mandatory requirements, the statement contains 24 core principles. The RICS has acknowledged that in rare circumstances, strict compliance with these might not always be possible. However, the core principles should be departed from a good, justifiable reason to do so. A selection of some of the core principles are set out below. All costs should be transparent so that parties are aware. Method of apportionment of costs should be demonstrably fair and reasonable. When issuing statements of accounts and or certifying expenditure, managers should do so in a non-partisan spirit, acting as experts. In addition to the manager's certificate, annual statements of expenditure should be supported by an independent review of the service charge accounts. The manager should procure quality service standards to ensure that value for money is achieved at all times. The aim here is to achieve effective value for money service rather than merely the lowest price. This is very important when it comes to service charges. Okay, so if you're a property manager and you're tendering a contract, let's say it's a cleaning contract, and you invite 3 cleaning companies to bid, they then come forward, and obviously there are 3 different quotes. Okay, it is not for you to select the lowest price. That's not the basis, okay, of your role. You are expected to select based on the value for money. So, for example, okay, if there was that was offering cleaning 7 days a week, days a week or 4 days a week, then obviously there's going to be more money. But proportionally, on a day-by-day basis, it might be more. It might be better value for money. Okay, so that deals with service charges. Now I'd like to move on. How are we doing for time? Okay. So firstly, assignments and sublettings. We talked about surrender. So when we talk about property management, one of the things that a property manager does on a regular basis is deal with the application on behalf of tenants who are looking to assign or sublet their lease. So a tenant comes to you and says, I want to get out of my lease. Either I can't afford to stay here, or it's surplus to requirements, or whatever, but I don't need to be here. But of course, there's a legally binding document called a lease, which ensures that they have to continue to pay the rent. They may not be able to do so. So the tenant comes to you and says, I'd like to assign. Before you answer the question, before you give an answer about assignments or sublettings, please ensure that you check the lease, okay? You look at the alienation provisions in the lease, because that will tell you whether assignment or subletting is permitted. And if both or one or the other are permitted, are there any conditions? So for example, normally assignment of a lease will be permitted subject to landlord's consent, not to be unreasonably withheld or delayed. Normally, subletting of the whole is normally permitted, not part. So if a tenant comes to you and says, I've got 2,000 square feet here over ground and first, but I'd like to get rid of one of the floors on a subletting basis, you don't have to grant them consent, because that's deemed as part. Now, you might want to take back a floor, but you don't have to. So there is this whole issue of the difference between assignment and subletting. Can anybody tell me? Well, you're looking at the screen, so you can see. Assignment means that the tenant has no longer has any obligations under the lease, unless there's an authorised guarantee agreement, and there's no direct communication with the landlord. So what we've got here is we've got, if you can imagine, we've got landlord at the top of the tree, and we've got tenant. Okay. The tenant says, I don't want this lease. I want you to have it, tenant B. Tenant B says, okay, great. Thank you very much indeed. All looks great to me. I'm now the tenant because I've taken over your lease and I'm responsible for paying my rent to the landlord. Okay. So tenant A is out of the picture. Okay. The relationship is created between tenant B and the landlord. Okay. Because they are the assignee. In the event, as we've talked about, that the assignee fails to pay the rent, the landlord can go back to tenant A and say, I'm terribly sorry, but tenant B has not paid their rent. Therefore, we're coming to you because you're the guarantor or because there's an authorised guarantee agreement to pay the rent. So, in the event, however, of a subletting, landlord, tenant A, tenant B, sublease. Okay. So here's a good question, good APC question. Hold on one second, there's a question. What about letting to a company where they sell the shares? Will the landlord have any remedy or protection against irresponsible new owners? So, Sam, are you saying that if a tenant sells their shares in the business, the new owners are then responsible for taking over the lease? And does the landlord have any? Yeah. So what happens is, in that case, And this is quite a legal point. But what happens is in the sale of the business, the lease is an asset, and it's a liability on the balance sheet. So what would happen is that liability has to be transferred by way of an assignment to the new owners. So they take on that. So in theory, the landlord would be permitted not to grant that assignment. However, it would be very unlikely to happen because a business buying another business that is paying money is likely to be a bigger company. Therefore, there would be no grounds to refuse the assignment, if you see what I mean. Hope that answers that question. Okay, so here's a question. Why would a tenant want to sublet rather than assign? Why would a tenant want to sublet rather than assign? Correct. I don't know who's given that answer because it's just come up as unknown user, but yes, the answer is there's a profit rent. Okay, so the profit rent is where the market rent is higher than the passing rent. Okay, so therefore, if the tenant is paying 50,000, but the market rent is 70,000, they will they will sublet it at the market rent of 70,000, but of course the tenant is the one responsible for paying the rent. So therefore they will keep the 20,000 profit rent, pay the 50,000 contracted rent to the landlord. Happy days. Unfortunately, you don't see that very often at the moment. So, to summarize, dealing with assignments and sublettings. Process, read the lease. Get an undertaking for your costs from the assignee. What is the covenant strength of the proposed assignor or subtenant? You know, we kind of touched upon this just a little earlier. There will be grounds for for landlords to refuse consent for the assignment of the property or the subletting based on the proposed covenant strength or even the proposed use of the subject property. Okay, so you've got to look at the covenant strength. Can they actually afford to pay the rent? Excuse me just 1 second. What is the proposed rent? Is it more than, the same as, or less than the market rent? Are there reasonable grounds to refuse consent? The Landlord and Tenant Act 1988 means you have to deal with the application promptly. If agreed, a license for assignment or subletting will need to be drawn up. What is the impact on the investment value of the property in having a, I've just got a guest with me, just bear with me 1 sec. What is the impact on the investment value of the property? Right, just a little bit more information on the Covenants Act of 1995. Let me just put my little puppy down because he's getting quite heavy. You have to go down, mister. See, some of you have little kids to worry about. I've got little puppies. So the Landlord and Tenant Covenants Act of 1995 came into force on the 1st of January 1996 and it replaced privity of contract. Now, privity of contract basically referred to the obligation of tenants to pay the rent for the duration of their lease, no matter how long it was. So, for example, in 1985, 1986, 1987, wherever it may have been, Marks and Spencer took a 99-year lease on a prime retail unit in wherever. Okay, 14 yearly rent reviews, that's their lease obligation. Okay. Now, under privity of contract, even if they're not an occupation, even if it's been assigned and sublet and assigned again and whatever, it is still on their balance sheet. Okay. At any point, because it's a pre-95 lease, at any point, the landlord can go back to Marks and Spencer and say, you are responsible for the payment of the debt because you signed a lease back in 1985 and there is privity of contract. Okay, so as I said, that now no longer exists. Privity of contract was now abolished, and the Covenants Act brought in authorized guarantee agreements. This is essentially a promise to continue to pay the rent in the event that your assignee fails to pay the rent. But it only happens, as I said, on one assignment, and it doesn't happen with sublettings. Okay. If you want to pursue a former tenant under the Covenants Act, Section 17 notice must be served within 6 months of the arrears. If the former tenant settles the arrears, then an overriding lease can be created. The Code for Leasing Business Premises says that an authorized guarantee agreement should not be a condition of an assignment unless the proposed assignee is of a weaker covenant. So there may not be an authorized guarantee agreement in the lease, but it can be added. So if, for example, as we going back to the example I gave you about the about Tesco, if you had a situation whereby the Tesco come along and say, I want to assign, you could say, well, okay, fine, but we're going to put into the lease that an authorized guarantee agreement has to be in place whereby you can only assign to a tenant of a similar covenant strength. Okay, so there's all sorts of ways of protecting the landlord's position. Right, excuse me just one second. I'm going to have a quick drink of water. As a property manager, you will be handling clients' money. A key role is the collection and management of sums owing by occupiers relating to rent, service charge, insurance, and any other sums due under the lease. It's important that a property manager has an established process in place to arrange for the efficient collection of these monies. This means that a property manager will have a thorough understanding of the relationship between landlord, occupier, and other occupiers in the building. Obtain wherever possible from the landlord copies of all relevant documents, leases, licenses, and so on. Understand from those documents the payment obligations. Maintain a database of the occupiers and other occupiers to record the financial position with each of them. Put payment processes in place so that the occupiers are clear exactly how much, when, and to whom rent, service charge, insurance, rents, and other amounts are due. Make sure that the payment process is clear so that no occupier or occupiers can argue that the amount due or the time of payment is not known. Have a mechanism in place to notify of any default in payment or a dispute over any payment, and promptly report this to the landlord in the manner agreed about such default. Have a process in place to pursue occupiers for defaults in payments. Have arrangements in place to forward sums collected, less deductions, e.g. service charge, onto the landlord. The landlord will want these sums to be forwarded as quickly as possible and report to the landlord on the reconciliation of the amount actually paid to the landlord and the amount collected. I won't go into the sort of the rules of conduct for firms, but please do ensure that you fully understand the rules of conduct for firms, Rule 8, handling clients' money. Essentially, the most important thing is that the client's money is held in a separate account, and it has the word client in the account name. Okay, and of course, you would agree as to who interest is going to be paid to. Now I'd like to move on, please, to the next part of the webcast, which is dilapidations. Dilapidations is a pretty complex subject, but it is relevant for property managers. Property managers often get asked to deal with the dilapidations at the end of a lease. And dilapidations is one of the primary differences between residential leases and commercial leases. The purpose of dilapidations means that the landlord is entitled to get the property back in the same condition as it was handed over to the tenant. Now, that's quite an amazing thing, that you lease a building to a tenant for 25 years, 20 years, 15 years. And they do all sorts of things. They fit it out, they improve it with landlord's consent, they decorate it, they reconfigure it, whatever. But at the end of it, it has to go back in the same condition as it was handed over to the tenant. So, what do? You review the repairing obligations in the lease to see if it's full repairing and insuring. The lease would also confirm if there's a schedule of condition. Now, when do we have a schedule of condition? A schedule of condition is attached to a building which is in poor condition. So in other words, if there is damp, if there is evidence of water penetration, perhaps the pointing needs to be improved, replaced, the windows are shot, there's woodworm, whatever. The tenant will say, well, hang on a sec. I don't want you to claim at the end of the lease that these problems, these issues are my fault, because when I took the lease, this is what was already there. So therefore, a schedule of condition is put together, which is normally a written record together with a photographic record, which says, this is the condition of the building, and this is how I would expect it to be handed back to me. If a schedule of dilapidations is served, it can be negotiated by the tenant. In other words, the landlord is responsible for putting together the dilapidation schedule, and it can be either that the tenant does the works themselves, or they pay an agreed amount to the landlord to do the work. In some cases, the landlord will go into the premises and do the works themselves, and then reclaim the money back from the tenant. There has to be a certain clause in a lease to permit that. For a bonus point, can anybody tell me what the clause in the lease is? Very good. Yes, Jervis and Harris clause. Ellie's got that. You get 1 bonus point. So there are 3 forms of schedule of dilapidations. An interim schedule. So during the lease. And the lease has to be for a minimum of 7 years in order for there to be an interim schedule of dilapidations. But normally where there's at least 3 years remaining of the lease, either by the landlord or the tenant. Refer to the Leasehold Property Repairs Act. Then we have a terminal schedule, served within the last 3 years of a lease. And finally, the final schedule, served at lease expiry, or after the tenant has vacated the property. The claim for dilapidations is based on the cost of the works or the diminution in value in accordance with Section 18 of the Landlord and Tenant Act 1927, whichever is the greater. Okay, so the cost of the works or the diminution in value, whichever is the greater. Does anybody have any questions about dilapidations? Now, finally, I want to talk about insolvency. Well, obviously, I don't want to talk about insolvency, but it's something that you may need to know about. Again, especially at the moment. And for those of you that are doing your final assessment in session 2, I think this is going to be okay. So there are, of course, different ways of dealing with insolvency administration. So an administrator can be appointed by the company, creditors, or the bank. In other words, anybody to whom the company owes money to. An administrator deals with the assets of a company over an agreed timescale. That timescale is known as a moratorium. The directors of the company remain in office, but they have no power. If the company in administration continues to pay rent, it can be claimed as a cost of the administration. Bless you. Receivership. The law of property act, receiver is appointed to sell off the assets of the business to pay off the debts. And then finally, the CVA, the Company Voluntary Administration. A company can enter into a CVA when they're insolvent, but they believe the business has a future and can continue trading. The company can agree a deal with its creditors to pay back a percentage of the debt, as long as at least 75% of the creditors agree. If a tenant becomes insolvent, what do? Again, this is a question that's often asked. Check the lease. Is there a rent deposit to draw down? Are there guarantors to pursue? Contact the administrator and register a claim for arrears. Make sure the property is secure. Inform the insurers. Don't forget that you cannot accept the keys back, as this will constitute a surrender of the lease. You can take the keys back to ensure the property is locked and secure, as long as you confirm in writing that this is for the purposes of security. It doesn't constitute a surrender of the lease. Okay. I've put it on some here, and I'm going to send obviously all these out to you. Just some questions for you to go through, which is relevant, of course, to property management. So, back on again. Any questions? We've been through dealing with tenant arrears. We've been through dilapidations. We've been through service charges. We've been through handling clients' money, assignments, sublettings. Any questions? You can either type them into the chat box, or you can turn your microphones on and you can ask away. If you do have any questions, it doesn't have to be on property management. You can ask any other questions if you want. When can you expect to receive a date for the assessment? So generally speaking, the dates come out 3 to 4 weeks before your assessment. So we really don't know at the moment how it's all going to work with obviously this sort of video conferencing. But those that are doing it in May, the beginning of May, have already received their notification. So it's being handled in exactly the same way. So I would say sort of 3 to 4 weeks. Just got a guest here with me. He's going to help you. In the commercial pathway, is there a likelihood that management insolvency questions may arise? Yes. Yeah, very much so. The reality is that when you're talking about property management generally, you're going to be faced with situations where tenants are going bust, and how do you deal with that? So yes, it is quite possible that insolvency questions may arise. If the interview is on Teams, will we receive an invite in the same way? The answer is, Sarah, I don't know. I don't know. In fact, what I'll do for you is, I know that some are doing theirs on the 6th of May, and they will have received their notification. So I will ask them what they got as a notification. Any other questions? Okay, well, that concludes this evening's session. I hope you found it useful. I'm going to send out these notes as always to the group, so I'll do that either this evening or tomorrow. If you have any questions you want to follow up, please feel free to do so. You can put this down for those that need to as 2 hours of CPD, which I will be signing off for you. And as I said, as always, you know where I am. Call me on the mobile, send me an email, send me a text, send me a WhatsApp, and I'll help out wherever I can. All right. So enjoy the sunshine, stay in, stay safe, all of that sort of thing. And I'll catch up with you on our next webcast in whenever it is next week.